You've worked hard all your life to hold on to your home, your business, and your plot of land. Suddenly, the king wants it for himself. In this case, the king is the government. So what are your options? And are you in for the fight of your life? We're going to find out in this edition of Pro Se Nation when we explore eminent domain law. I'm Mary Lynn Schiavi, and welcome. Joining me today are two attorneys from the law offices of Waters McPherson McNeill, based in Secaucus, New Jersey. Robert Lipschitz, an associate, and Blake Davis, a member of the firm, specialize in eminent domain law. Both attorneys work within the firm's eminent domain practice group, which provides representation in cases involving governmental acquisition of real property and related matters, including roadway access, relocation assistance, and environmental remediation of properties being acquired. Thanks for joining me today.
Hi. Good evening.
Hi, Mary.
Thanks. So most of us have heard the term eminent domain, but we have kind of a fuzzy understanding of what it's really about. So because this program is to really teach the average person about the law, I was hoping that we could begin with kind of an overview of what eminent domain is and a little bit of about the historical perspective. So would you like to take that, Robert?
Sure, Marilyn. At its simplest term, whether you call it eminent domain or some people may know it as condemnation, it's basically the right of the government, whether it be the state government, the United States government, federal government, or local, city, county, or agency, their right to take property and take private property and put it to public use. It goes back, as you can imagine, as long as there's been governments and the need to do something for public use, like a road or a bridge, going back to the Roman Empire, there's been talk of takings. The first written concept of it goes back to the Magna Carta, all the way back to the year 1215, and where the British government had the right to take, it specified that they had the right to take. Unfortunately, for a lot of people, it didn't mention anything about paying for that property that they were taking. So that, was a problem, probably unspoken in the British Empire for a long time until us crazy Americans came in. And during the American Revolution, that was one of the key grievances of the colonists, along with taxation without representation. The quartering acts, where the British government could just take somebody's home or business and put troops in. So that was one of the major grievances of the American colonists. So James Madison, in drafting the Constitution and the Bill of Rights, decided he wrote on the subject of property extensively during that time, and he inserted in the Fifth Amendment the phrase, "Nor shall private property be taken for public use without just compensation."
Okay. Right, and that's the basis for constitutional law, takings law, is that there has to be payment of just compensation, and it has to be for a public use. And there's been a lot of arguments over the years over exactly what just compensation is and what constitutes a public use. And we'll go into that a little bit later, but there's been a lot of litigation over both of those concepts. And there's, in addition to the federal Constitution, there's also a provision in the New Jersey Constitution that limits the acquisition by government of private property to public use and payment of just compensation.
So now, as I understand it, only government bodies can do this, but is there ever a situation where a private entity can take property?
No.
And what about
In
utility
certain
companies?
instances, a utility company, which is technically a private company but could also be considered a quasi-governmental organization, can acquire property with permission from the Board of Public Utilities, also on payment of just compensation, and of course it has to be for a public use. But in addition to the government, units of government such as the Department of Transportation, governmental authorities such as the School Construction Corporation, or I think it's called now School Development Authority, can also acquire property via eminent domain. There is also the Casino Reinvestment Development Authority, which has acquired private property down in Atlantic City for the casino development areas down there. They also have the power of eminent domain.
So in terms of New Jersey's eminent domain laws, how do they stack up compared to the rest of the country?
No, they all have the same concept because they're all following the federal model of just compensation has to be for a public use. Some states have decided to be a little more permissive. They specify in a little more detail about what can be done and how the taking has to take place and how the payment has to be made. But in the end, they're all following that model. Florida notably pays for the property owner to get an appraisal, which is it can be a major expense. That's something they've decided to do. They've put the money towards that. New Jersey, that's not the case. You, as a property owner, you have to pay all your own expenses going forward, even if you win the case.
And in terms of, so this question of just compensation, how do you arrive at just compensation? Do you get 3 appraisals?
Basically what happens is the government gets an appraisal. The appraiser has to contact the owner. The owner gets a chance to talk to the appraiser on the property. Government has to answer questions. They come up with an appraisal. They make an offer to the property owner. The property owner can then get their own appraisal. They can discuss and negotiate the purchase price. And only after you've had negotiations, and if negotiations fail, can the government acquire property through the litigation process. And that's actually called condemnation. That's the difference. It's all under the rubric of eminent domain, but the act of acquiring property through litigation is called condemnation. But it's different from condemnation in the sense of somebody condemning a house for the fact that it's not good or it's in bad condition.
So why do they call it condemnation?
I have no idea. It's just confusing.
It sounds like they're okay. All right. It sounds like they're getting around it by condemning the property, but it's not the same thing.
No, it's
okay.
It's just one of the things that gets a little confusing. And there are a lot of wrinkles in the acquisition process. For example, if the property is contaminated with environmental contamination, the New Jersey Spill Act confers upon government a conditional immunity from having to pay any cleanup costs. This gets extremely complicated because government may actually acquire a property that is found, and as part of the inspection process through the acquisition, it may discover contamination, and the contamination may end up exceeding the purchase price of the property.
And the property owner has to pay that?
Yes, the property owner.
Oh my God.
Yes, this can lead to some very, very bad results for property owners.
That's crazy.
It seems that way. And I've actually represented property owners where contamination is either known or discovered on their property, and they've been offered $1. So these are people who have been operating a business on their property, basically happily enjoying their business. The state comes along and says, we need your property for a public project. They get an environmental consultants who do an inspection of the site. They find contamination. They say, okay, fine. We're going to offer you $500,000 for your property. That's the good news. The bad news is It cost $750,000 to clean it up, so you owe us $250,000.
What's to stop them from throwing some oil on the property, right?
That doesn't happen.
It doesn't?
No. And actually, I've had a bunch of cases with environmental issues, and generally, I have to give credit to government. They have tried to bend over backwards for people in that situation, and try to make things as fair as possible given the circumstances.
Now you're saying, Robert, you started to say, or you were saying that, so the property owner in New Jersey, if someone wants to take my property, they want to do something with it, I then have to pay all the legal fees to fight the battle.
Correct.
And even and get the appraisals and all of that.
Correct. Well, you'd start by hiring a law firm usually.
Right.
And that's where we come in. We represent property owners. Sometimes we represent the government. But you start with that, and we have contacts. We talk to appraisers every day. We hire the experts. Sometimes you need an expert planner. You need an expert engineer because there are various issues that...
So what if the property owner can't afford any of this?
Then they take the offer. And that's unfortunate.
Wow. Because that really leads to my next question about who is most vulnerable in this process?
Well, vulnerable is if you're talking about who could have their property condemned, it's anybody who has property.
Right.
If you have property, whether it be physical property or intellectual property, you're subject to condemnation. The government has the right to take it. But, if you're on a heavy intersection that needs to be widened, if you're near a highway that needs an on-ramp, or they're talking about that, that's where the possibility of eminent domain is most most at its tipping point, where the turnpike for years below exit 8A was you hit that traffic as soon as you got by exit 8A, and where the car lanes ended and the truck lanes merged. So you knew if you had property somewhere south of there between that and the Pennsylvania Turnpike that eventually they were going to have to widen that. And sure enough, the last 5 years they've been working on that. So
that seems like something that people shopping for a home should really take into consideration, right? Like, is there any way of kind of assessing the risk?
Well, that's one of the things we talked about before, but let me take a step back. You were talking about how do you pay the expenses if you're going to be acquired. And one of the protections that government does provide to you is that when they actually acquire the property through the litigation process, through the condemnation process, they have to take the money that they've offered, assuming that there's no contamination, and put it into Superior Court trust funds.
Right.
And the owner can remove that money, withdraw that money, subject to any other mortgages or liens of record, and use that money while they litigate whether they're entitled to more money. And there's law in New Jersey to the effect that the government cannot argue for a lower value than its offer. Case law that says that. So if the government offers you $500,000 for your house, and you actually litigate it, the government cannot go and get another appraisal and say, well, now our offer's $400,000. It's stuck with the 500. Although it's not quite the right way to put it, but they don't. You'll get your the $500,000.
With the exception of if you own a home and you have an oil tank that's in the ground and they think it's leaking, then they can withhold money. So that $500,000, if they think it's going to cost $100,000, which it very well can, depending on how much it's leaked and how much soil has to be removed, they could withhold that. So now you're only entitled to the $400,000. And they start, you see in that dwindle, that separate holdback amount, that $100,000 will slowly dwindle as they pay for consultants and construction people to dig it out and do the testing and monitoring of groundwater. So that's something that I think everybody should be aware of. If you've got some kind of old oil tank that's been in the ground and somebody told you years ago maybe that was leaking and you just didn't want to pay attention to it.
Right.
If there's a risk of condemnation, you better have somebody look at that, because that could be a disaster. And
Wow.
and it has been for some people.
Wow. What would you say is most important for the average person to understand about eminent domain law?
Probably what I would say is keep abreast of what's going on in your community. And this is not necessarily as to eminent domain so much as the project for which the acquisition is needed. If you are going to make an argument, if you as an owner of a business or a home are going to make an argument that your property should not be acquired, you need to get involved early. So you need to know what's going on. And the way to do that, obviously, is to keep abreast of projects that are either proposed or contemplated by your local government, the Department of Transportation if you're on a major highway, county government if you're on a county highway. And then through the planning process, you can try to insert yourself and say, hey, maybe I shouldn't be acquired, or you should change your project in such and such a way so that the effect on my property is minimal. It also gives you an opportunity to maybe acquire land adjacent that might mitigate for the acquisition. Generally, once a project has started, if it's for a public use, you're going to have a very difficult
The train's
time.
already going down the track.
Exactly. You're not going
See,
anywhere.
to me, the thing that is most disturbing about this, I mean, I can understand if it is an absolute critical need. Maybe there have been multiple accidents on a specific road because it bends a certain way, and it's like the only way to fix this is to straighten this road, and we're going to have to take somebody's property. On the other hand, you know, when it comes to just compensation, like I think about my home, and it has so many, it's the memories involved. It's the emotional attachment to something, you know, you've put in gardens, or you've put your blood, sweat, and tears into it, and now somebody just wants to come swipe it away. Like, that's very disturbing.
Well, it goes to the value of the property. It's unfortunately, all the sentiment doesn't really play into what the ultimate just compensation is. It's really defined as fair market value, which is simply what a willing buyer and a willing seller, just like if you were to sell a home or a condo, you know, what would the realtor come in and say you could get for it? And that's what it is. And you have, you know, that you painted something nicely, or that you have some kind of sentimental.
You planted beautiful hydrangea bushes.
Maybe that adds to the value, maybe it doesn't. But in the end, it's, you know, what it's worth on the open market. You know, you have that great pool back there.
My dog's buried there.
Oh, well, that might lower the value. But that's unfortunate. And we run into a lot of people who think, as a lot of property owners do, that this is the most valuable piece of property in the world, I wouldn't sell it. And they think of that famous Atlantic City case where they wanted to build the casino, and that elderly woman held out and they had to build the casino around her.
Wow.
With roads, they can't do that. They would just take it, and that's the other part of this that's heartbreaking. They just do it. You know, they negotiate, but as soon as the negotiations, if you can't come to a price, that's it. They file the court papers, and it's basically done. And there are some ways to oppose that and make sure they did it right. And you can, but at that point, they take it, and they're just arguing. You know, we're just arguing over the value of the property, how much money you get in the end.
Right. Well, and Blake, as you were saying, maybe you know, it's a good thing to be in touch with what's going on in the town. You can't fight City Hall, but you should at least be friendly with City Hall so that you maybe are in a better position to negotiate, perhaps?
Well, yes. And you also have to remember that in addition to compensation for your property, the government is obligated to give you relocation assistance, which has tendency to be more generous in terms of residential relocations. Businesses somewhat limited, but they will pay for your moving costs. They will give you a little bit of money for to change the place that you're moving to accommodate whatever personal property is being moved. But governmental regulations for residential relocations do give you fairly significant money if you meet certain qualifications, which are a little complex. But my experience with residential relocations is that they are the most difficult ones because people don't want to move from their homes. And I had a case up in Sussex County where these people lived really next to the highway, where you literally the smoke was blowing into their home from trucks going by.
Right.
And
But we love it here.
Right.
This is our home.
Well, that's true. And we got them into another place that was really much nicer than their. And they were not happy at all. They had been in that house, I think, for like 2 or 3 generations. So, it's heartbreaking. And sometimes money just doesn't make the difference. But we try to do it in a way that people feel, at least, if not happy, not unhappy. So.
Well, before we get into, I would like to ask you about a few cases, and but how often are people justly compensated? I mean, and again, I know that's it's very relative, especially if there's a lot of emotional attachment. It's kind of like, as MasterCard says, priceless, right?
It really depends who you ask. It's if you ask most property owners, they'd probably say it wasn't enough.
Right.
If you ask the government, we give them more than they probably deserve for that property that doesn't look like it's worth very much.
Right.
We've had clients where they didn't pay a lot a long time ago, and all of a sudden the development came around it, and look, hey, it's a lot more than we paid for it, and they're happy. So they would probably think they were justly compensated.
Right.
But the problem is, as we discussed earlier, once you start hiring an attorney, and once you start having to get an appraiser and other experts, even if you get the number, even if you get that $1 million that you think your property is worth, you've spent money to get there. So you're never going to be at that number. And that's the unfortunate part of this process.
Wow.
That's true.
So do each of you have horror stories to share or good news stories? What would you say? What are some?
I can tell you a couple of them very quickly. We're talking about satisfied or unsatisfied. We just represented somebody whose warehouse was taken by a major agency. The original offer was $6 million, and we settled for $13 million.
Okay.
But
sounds like good work.
It was good work, but it was a very difficult process convincing the agency that we were entitled to the additional money. We had to really point out some errors that were made in the the offer that was made by this particular agency. I mean, we obviously, given the wide swing, we had to provide a fairly comprehensive set of proofs. That is the good. The bad is another person we had represented who owned a 3-family house where the government had argued that she over-improved the property. And as it turned out, even our own appraisers were saying the same thing. In other words, she put an enormous amount of money into the property.
Right.
Such that if the property was sold, she'd never get it back. And while we did negotiate an agreement that gave her back most of it, it did not give her back certainly what she thought she was entitled to.
Right. We have a few more minutes, just a few minutes, and then I'm going to ask you actually to stay for another round of questions, if that's okay.
Sure.
But one question, how can eminent domain be abused? When is it really when is it used in a kind of underhanded way? It's hard to answer that because government obviously is not supposed to be doing that.
And let me just mention something. This used to be a very sleepy practice. I've been doing nothing but eminent domain work since about 1990. And up until the Kelo case, Supreme Court Kelo case in 2005, this was pretty sleepy practice. Kelo, of course, was a Supreme Court case which ruled that in certain instances, a government can acquire property for redevelopment and ultimately give that property to a private developer. And that rubbed a lot of people the wrong way. It's difficult to do in New Jersey, but it obviously, the case arose in Connecticut. It is possible. Ultimately, the irony, of course, is that the property was acquired, but the project was never built.
Okay.
So people did lose
Well,
their homes.
I will get, when we come back, I'll ask you more about that case. And thank you so much for joining me for this segment.
Thank you for having us.
And thank you for joining us for this edition of Pro Se Nation. If you are interested in being a guest on the show or would like to recommend a topic, please join us on the web at prosenation.org and also on Facebook. Thank you so much, and I'm Mary Lynn Chiave. See you in the future.